Hey everyone, welcome to GovCon 101, Artificial Intelligence in Government Contracting. I'm PCI's John Plinky, joined today by our expert instructor, Tyler Evans. Before we get started today, I want to go over the housekeeping announcements. Be sure to listen to these because these will explain how to get a certificate, what kinds of certificates we can offer, and all of that other important information. So, if you are eligible for credit, that means you're a subscriber at PCI or you signed up for this class using the CPE CLP option, you'll be able to find this course under My Certificates and Courses when you log into our website. If you've never logged into our website but you used one of those options, it won't be available to you, so you'll need to email me. If you don't know what that means, but you think that you're eligible for CPE or CLP credit, you can email me as well. I'm john@publiccontractinginstitute.com. If you only need to take this class for a certificate of completion, that's just a certificate saying that you were here and that you took the class, so you can show somebody, show that that's what you were doing right now. That will automatically be emailed to you if you take at least 85% of today's class. In addition to that, during the program, there will be polling questions. The first polling question is on your screen right now. It asks, how much government contracts experience do you have? These polls, alongside the 2 passports you'll need to collect if you need CPE or CLP credit, are part of the accreditation process. I'm not just trying to gather information. This is a touch for our CPE. So you need to respond to these if you need credit for today's class. In addition to that, we invite your questions. This is a relatively information-dense class, so while we will answer questions if they come up at relevant points, we'll probably hold a lot of them to the end, because there's a decent chance we will need to answer them after the original allotted time is over. All right, I'm closing that poll. It looks like we have a good mix of experience levels today. Opening up the next starter poll here. Where do you work? We'd love to know where you work. And so once again, thank you all for joining us today. We invite your questions, and remember to write down the passwords so that you have them when you need them. All right, thank you, everyone, and take it away, Tyler.
Great, thanks a lot, John. And as John said, I'm Tyler Evans. I'm a partner at Steptoe LLP, a law firm here in DC, and I've been doing kind of cutting-edge, new technology type legal work in the government contract space now for a little over a decade. I love this stuff. AI is absolutely, important to everybody, but it's been kind of a critical part of my work going forward, and so very, very happy to be here. Always happy to be here with PCI. I think they kind of run great programs on a variety of different issues. So as John said, we do have a pretty packed agenda today, and I'll throw up the first slide to just kind of give you a sense of what's to come. But essentially, what I think we'll try to be doing here is go over kind of the overarching frameworks that will be most relevant to a lot of you on the call, and hold a lot of the kind of more niche specialized issues of maybe data rights or some issues if you're doing cross-border transactions and things like that, that I think are still broadly important to consider as you look at AI and government contracting. But on a lot of those, they're going to be kind of use case specific, right? So the way we structure the presentation today for our 75 minutes is to give kind of a general overview, make sure we're level setting on kind of AI, what types of AI are relevant, how is AI used, how should you be thinking about this, that kind of thing. The existing kind of baseline that's out there for how the government's looking at AI, particularly with respect to government contracting. The new framework that came about in 2025, you probably heard about it, a new executive order, a new memoranda from the Office of Management and Budget. And then we'll have that kind of last section on kind of the more specialized issues of some of the intellectual property issues that come up and things like that. And I think if we go according to plan, we'll probably get through most of the intellectual property issues, and then kind of have a few cross-border transaction slides maybe for you to reference as kind of, oh, I should be considering these points as well. We might be able to get into some of them. And then there's definitely kind of a chunk at the end that's just purely a separate appendix. We're not planning on getting into that at all. If any of you are working in national security systems, so in the intelligence community with a lot of DoD weapon defense, weapon systems, things like that, there are kind of new rules and heightened requirements that you should be considering. A lot of that is in kind of the slides at the end, but again, that's kind of a specialized situation, so we won't kind of spend time on it today. As John said, I love questions. I absolutely do. Today, we will probably do a little bit of a different thing where, if it's totally relevant to the slide, I'll raise it and try to get into it at that point in time. But for a lot of them, we'll probably hold them to the end if that's kind of going to be an issue. And then I think, you know, if something's not clear, if you need me to repeat anything, go back, anything like that, please feel free to kind of put that in the questions as well, because it is always helpful to kind of address those issues. If you had a question, somebody else probably does as well. So to start off on kind of the overview, we'll look at the examples of kind of AI, just how to think about things, some of the general legal issues that come up with respect to AI and what people are thinking about in the legal world on these things, and then how that applies to contracting, and then some definitions of AI as well. So in terms of examples, kind of what do we mean by AI, right? I get all sorts of questions about this all the time. And the basic takeaway, I would say, is it's not your basic chatbots, right? It's not ChatGPT. It's not kind of that kind of thing alone, right? That's obviously what everybody thinks about when they think about AI, but there are plenty of artificial intelligence systems coming online that are behind the scenes, that are not necessarily working with humans or not necessarily working with the chat interface. They're kind of an automated system for targeting, identification, accomplishing tasks, all sorts of things like that. So it's a whole broad universe of kind of applications that we're talking about, not just your traditional chatbots that you kind of see in the news. So to break down just some common concepts and things to think about in terms of how you bucket things and categorize them. So most AI that you'd probably be dealing with today is probably machine learning based, right? You've probably heard that term before, but the whole idea is that there are majority of kind of modern AI that you'd be talking about in the last couple of years is a algorithmic system. It has a very complicated statistical formula, essentially, that it keeps updating based on experience. And so it kind of learns from chats that are going in, from training, from labeling in that data and things like that, and gets better over time is the goal, right? And so that's kind of the big thing. That is to differentiate, though, there are some pre-programmed aspects of AI. There are kind of autonomous systems and things like that. And you always want to keep those two distinctions in mind. Is it kind of pre-programmed, or is it kind of something that learned by itself? Because that really matters for a lot of the regulation that's coming out in this space. If you're purely just pre-programmed, you might not be covered. And so I think a good example that I think of in my head for that type of thing is something like earlier search engines, right? So I'm sure you've seen on Google and other things recently, you know, you get these AI summaries and there's AI kind of baked in the entire thing for many years now. But originally, you know, search engines just basically did keyword documentation of the entire internet, right? And just had a massive database. And yeah, there were formulas about how to get you to a particular result, but it was kind of a pre-programmed, determined thing. It was not the machine learning by itself. So that's a big distinction between the two. Then you have computer vision is another thing. So there are many AI applications that are being used to allow computer program software to kind of work with images, video, things like that. So all of that kind of generative content that you've seen below that is natural language processing. So that's what you see on the chatbots, things like that. So it's kind of using these statistical formulas to output something that would be understood by a human, right? And so those are kind of two sides of the same coin, the image-based systems and then the natural language processing systems. You have expert systems is what they often call them, but there are all sorts of things that many of you are probably using in your organizations that are AI for software coding, for example, and helping people kind of really get in a niche area results and output through the AI systems. And that's kind of something that you've seen a lot on. Robotics is obviously kind of a field that's always been there, but that's increasingly being talked about of kind of AI being embodied in physical form. So whether that's your traditional, you know, robot from a movie or an autonomous drone type thing, it's some kind of application of AI to a physical construct to kind of operate. And we'll talk a little bit that there are some requirements that might apply to that in kind of a heightened way, but that's another category. And then the last, you've probably heard about agents and agentic AI and all those kind of buzzwords and things like that. There's a whole host of AI that kind of help either other AI or people kind of perform tasks. And so a basic example that's always used is, you know, booking appointments or something like that. But the idea is that there are AI systems that are kind of go-betweens and they orchestrate and run a lot of different AI at the same time and all that kind of stuff. And so you do have kind of these different buckets. And again, that matters for some of the regulatory definitions that are kind of coming out and then would have a direct impact on kind of the contract requirements that go along with that. In terms of general legal issues, and we'll just kind of issue spot these right now, kind of spend a ton of time, there's slides on some of these issues, but just to flag kind of a lot of the issues that are coming up across the spectrum for people in law firms and advising clients and things like that. So intellectual property is still kind of one of the forefront issues. You've probably seen a couple of days ago, there was a big settlement involving intellectual property, but kind of what do you do when people are scraping data, using that to create AI models? Then when that's used in operation or putting output, who owns all that, who owned it originally, was there infringement, all that kind of stuff. So those issues are all there whenever you're using kind of AI systems, and that would be relevant in contracting as well when you're using it for the government. There are also investment issues. So not only investment in AI companies from outside the United States, so that would be Committee on Foreign Investment in the United States has jurisdiction and looks at AI transactions now, but there are also new rules as of last year about US individuals investing in companies outside the United States that are kind of working on AI systems. And the idea is, from a national security perspective, the US government doesn't necessarily want kind of their funds and wealth going to help develop and kind of speed up another country's program, right? Data regulation is out there. Most lawyers who say they're an AI lawyer are actually just a privacy lawyer that are putting on a new hat, right? Privacy is kind of a big thing about whether you're working with individually identifiable information, things like that. But then you also have export controls, right? So what happens if you're in a defense market and you're using export controlled information under the International Traffic in Arms Regulation, and you're using that to train a model, right? Does that model become controlled? What about the outputs? All sorts of questions that are coming up there. Localization is another issue. That's the term I use for kind of where does the data sit at rest. So where are your data sets? Where are you processing data and queries and things like that? And there's a big push and a lot of kind of consternation in various countries about, no, they want it only in the United States. They only want it in UK, right? That kind of thing. Hardware, if you're involved on the chip side of things, there's a whole host of things, but a lot of that is tied to export controls, stuff like that. If you're a public company, we've seen a ton of stuff on kind of Security and Exchange Commission enforcement. So AI washing, you're kind of bragging too much about what your AI does, right? That's kind of something that's definitely out there right now for a lot of issues. What I would generally call kind of AI safety, a broad bucket of consumer protection issues, discrimination, bias, and hiring. I'm sure you've heard about product liability. Are you causing harm to individuals, causing them to cause harm to others, right? Things like that. And then broadly kind of security requirements of cybersecurity, things like that. And so all of these are impacted by AI in one way or another, and they might have unique applications as to how they apply to AI. And that's slowly going to work its way into kind of contracting with the government, as we'll see from some of the new standards that are coming out this year and the last couple of years as well. And then our last kind of just overarching kind of description here, and won't kind of spend a ton of time looking at these in intricate detail, but I will just flag that there are various statutory and regulatory definitions of AI right now. The two that we have here for your materials are the National Artificial Intelligence Initiative Act of 2020, and then the National Defense Authorization Act of 2019. And these are used almost interchangeably. So each authority that comes out references either the 2021 or the 2019 version, and they keep going back and forth, and it's kind of confusing if you try to track it. But I think there are a couple of takeaways from these definitions, right? The first is the 2021 is pretty kind of limited in terms of it tries to cast a broad net, but it just talks about the function, right? And so what it's saying is we're really going to focus on kind of, it's a machine-based system and you're making some kind of predictions or inference. And essentially you're saying that it is an AI model that is using its statistical formula to say, based on prior experience, based on logic, based on what has been fed into the system, this is what the result should be. And that's either an output from a chatbot or that's the result of a task. It turns the switch on and off, right? Things like that. But that's what's meant by inference. And that's kind of the core to the definition of this National Artificial Intelligence Initiative Act of 2020. It does not talk about machine learning and continual updates and things like that. So you can have a finished model. It's already been trained. It's no longer being updated. And that's obviously still considered artificial intelligence under this definition. It's also not as broad as kind of pre-program or pure autonomy type issues. So I mentioned earlier the distinction between machine learning and then pre-programmed issues. Well, pre-programmed is not covered by this definition, right? And so even if it's unbelievably complex, a search engine result system for the internet, if it's pre-programmed, it's not covered, right? It has to be kind of something that learned on its own in many ways to kind of get there and then make inferences based on that learning. The three buckets here at the bottom, basically just to say, all three of these are probably covered by this definition, right? So generative AI is it's creating new content. Again, when you see image generators, things like that, chat content, whatever it is. Extractive AI, you're looking at a massive database and looking for hits of particular language. It's in intelligence activities and you're looking for threats, right? Whatever it is, that would be extractive often. And then agentic AI, I talked about earlier, kind of helping everything else, all the trains move on time, probably all kind of covered by this definition. And I would say this is probably the broadest definition. So most things, if this is the one that's applying, are likely going to be kind of covered by this in some way. That is to contrast the National Defense Authorization Act of 2019 definition, which right now is the most relevant definition for government contracts. So the things that have come out this year really focus on this definition. And it's a bit cumbersome, right? Instead of giving this kind of very broad kind of definition of, it's anything that does inference, basically, right? It gives you all these categories and says, yeah, well, if it falls into that, falls into this, falls into that. I would say the biggest one is the performs task under varying and unpredictable circumstances without significant human oversight. That probably covers most of what you're thinking of as AI, right? And I think generally that's probably going to have very limited kind of daylight between the two. But you could have some situations here where some of that pre-programmed AI that I was talking about, where it's kind of not something that went through machine learning and all of that, but it's a very, very complicated set of programming, essentially, that could be covered under that first prong. And so kind of this NDAA 2019 definition, you could actually get some broader systems on that. The other thing I would point out by this is they have this kind of catch-all at the end about, look, it's anything that's kind of embodied in a robot that kind of acts like a person, right? That kind of thing. And the definitions are so broad that, you could have, when all the requirements ultimately get implemented in the FAR, this NDAA definition might actually extend to kind of systems in their entirety, right? So whereas the prior definition focuses really on kind of the software model, that kind of thing, this definition gives examples of whole systems and all that. And so you could have regulations applying not just to the AI component, but all the firmware and the hardware and things like that. And so I would just say this is kind of a looser, more cumbersome, broader definition. And unfortunately, it's the one that's being used for government contracts right now. And so that really is kind of likely to be the one that you start seeing in the FAR and all that as things get implemented. So that's kind of the overview of kind of thinking about AI generally and all that. And so we'll talk now about specifics kind of going into government contracts. What are the authorities we've been looking at so far, and kind of how are they informing what came out this year? So the first set is these are two Trump administration executive orders from the first term that are still in existence, right? So there's actually a principle that you'll see on the next slide, a discussion of national security memoranda, but executive orders or national security memoranda that are issued by an executive survive the expiration of their term, right? So if Trump issued something, it keeps going in perpetuity until it's rescinded, basically, right? And so you did have some Biden orders that were rescinded, but these original Trump ones were not. And so they still remain kind of in effect. And so the first one you see there really kind of just sets the tone of kind of, look, we really need to look at these AI issues. But I think for government contracting, the key points are, one, it started to talk about, and you've seen this kind of common refrain in various authorities since, that there really should be a broad access to federal data and compute resources. So the federal government, through the Department of Energy and various kind of agencies, has supercomputers, right? And a lot of the kind of compute power that is needed for AI, the federal government could offer in kind of various unique applications. So there's a recognition of that, and that would be if you're doing cooperative research and development agreements and other forms of contracting with the government. There's definitely kind of a push, and various laboratories, national laboratories, are starting to open their doors a little bit more for that type of stuff. Same thing for federal data, right? The federal government has such vast amounts of data that would be useful for training AI that there's kind of a recognition that, look, we should probably open that up. The other thing, kind of a second issue on maybe three to take away from this first one, is that this really did say, look, the Office of Management and Budget, which you've heard about all over the news for lots of things in the administration this year, but the Office of Management and Budget and the National Institute of Standards and Technology are going to be kind of key players in how the federal government regulates and uses AI kind of going forward, particularly with respect to its own use and procurement of AI, right? So in government contracting. And there, OMB is kind of setting the tone in terms of overall rules. And then NIST, you might be familiar with on the cyber security side, actually gets into the nitty gritty of kind of, well, what exactly is required on cyber? They say two-factor authentication. What do we need for AI and kind of auditing that type of AI and things like that? So those are the two that are coming out of that. And then the third takeaway I would just say is the AI action plan. So essentially there, that just came out in June, but it was set all the way back in 2019 that, hey, we need to have kind of a overall agenda about next steps for AI in the US government. The next one about the kind of promoting use of trustworthy AI in the federal government, this one was really the first one about AI use in the government itself. And that's, of course, relevant to government contracting because essentially, right, if you're selling AI to the government, using it in performance, in many ways that might be viewed as use by the federal government. And so restrictions that apply to the federal government with respect to AI could very well apply to kind of what's being offered by a government contractor. Now that's to distinguish, right, you might be using AI for internal employment decisions that have nothing to do with your government contract, right? And so that's kind of a separate issue, and we'll get to some of that as well. But a lot of the kind of federal use of AI rules are relevant to contractors because they often kind of flow down in a particular way to government contractors. So I would think about it as, if you're familiar with the Federal Information Security Management Act or FISMA and some other FedRAMP, things like that, there are a lot of requirements the government just basically punts on and tells its government contractors to pick up, right? And so that's kind of what a lot of these orders on the federal government should be doing X with its AI. That's why they're relevant and starting to kind of come into the government contracting world. So this first one that came out, did have essentially some provision of kind of civil rights, civil liberties, things like that. And I'll say that you might have heard reports that the Trump administration in the second term kind of abandoned a lot of the Biden administration focus on safety and things like that. I don't think that's entirely true. I think this original order and then even the more recent orders still recognize that AI presents a risk for discrimination in employment, right? Things like that, and that those have to be mitigated in some way and take steps to kind of mitigate those types of risks. I will say, though, there's definitely a difference in kind of emphasis, right? So whereas this order and the new orders focus on kind of dominance in AI, getting it out as soon as possible, making sure we maintain the lead internationally, things like that. The other orders were much more focused on safety and making sure we do it responsibly and all that. So it's more of a tone thing, but not that it's completely absent from one or the other. They also kind of started this idea of, look, agencies, when they're using AI, need to essentially have kind of continuous auditing functions, ability to kind of stop the AI and things like that. And that will come up in kind of a requirement that's ultimately implemented this year. Transparency about how the agency is using AI, that comes up as well in the requirements this year. And then they also called out, if you look at the national security appendix for the presentation, these DoD ethics guidelines and intelligence community ethics guidelines. And so they're starting this kind of separate path of national security systems. And national security systems are generally exempt from a lot of the newer rules, but then have their own set of rules to consider that are similar in many ways, but are often streamlined and easier to handle for obvious reasons. Okay. So the National Security Memorandum, speaking of that exactly, how are they handling those? This is the only kind of slide that we'll talk about on this, just in case you have an interest. And again, there are additional supporting materials at the very end. But essentially, there are two national security memoranda that are out right now. One is classified, right? So we just have a reference to it and some general discussion of what it says. That's the first one there, so not much to say about that. The other one from 2024 is probably still in effect. And so it's a little bit odd. It's a Biden administration national security memoranda on how to handle AI in national security systems. And from what I can tell, there has been no Trump administration replacement. It was not part of the rescission of kind of the other Biden administration rules. And so there's a good basis to believe that this is still kind of a governing rule here. And I think on that national security memorandum, there are some important pieces in there. So it talks about prohibited uses of AI. It says straight out, you cannot use AI for these particular functions, right? That kind of thing. And so that's a very important guideline. If you're using AI, developing AI for the government, and it's going to be used in a weapon system for intelligence community purposes, things like that. It also talks about kind of emphasizing that CFIUS, so the Committee on Foreign Investment in the United States, really needs to start considering, well, does the company involved that's getting investment from a foreign investor do any kind of AI type issues, right? So AI training, things like that. And so that's not, it goes a little bit beyond the current CFIUS rules and says, look, you should be looking at this kind of regardless whenever AI is involved. And so that heightens the risk whenever you have a foreign investor, if you're in that kind of situation. They talk about kind of this voluntary security testing. So you might have seen that a lot of the large language model companies signed up last year to get their models tested, and they kind of continue to do that. So that's still going on from this memorandum. And then, there's kind of a risk management framework there. And so you have a risk management framework now from the new rules that came out this year, which again we'll focus on today. But there's this corresponding one for national security systems that again is probably still in effect. And so, I say national security systems are exempt from all the stuff that we'll talk about for the remainder of today. Well, there is a lot of overlap. I just realized that there's a separate memorandum out there that you can look at for a lot of those issues. So the final point about kind of the existing baseline and authorities is that the Biden administration, I mentioned this, but the executive order there and then the corresponding Office of Management and Budget memorandum were rescinded, right? And so that was a big part of kind of President Trump's campaign, that he was going to draw this stuff back. And so all of that was kind of kicked out. The OMB memorandum referred to something called safety and rights impacting designations. And so you had to say, does this AI impact individual liberties and rights? Does this AI impact safety, maybe national security or individual safety, physical harm, things like that? That's all by the wayside now. But you have a very similar framework that came out in basically April of this year. And so we'll walk through that. But that's kind of the what's standing still and what came to date before getting into the new framework. So John, I don't know, is now an okay time for your password, or do you want
Sure. Let's do the first password now. The first password today is the word beautiful. Beautiful. Write the word beautiful down. If you need CPE or CLP credit, you need to submit the password beautiful alongside the second password on our website under My Certificates and Courses if you need CPE or CLP credit. Beautiful. Beautiful. All right, take it away, Tyler.
Great. Thank you, John. Okay, so now into the new kind of framework. So a lot of that's just background setting and all that. Here's kind of, okay, well, what's actually happening now? How does this impact my contract? Kind of what are the nuts and bolts of those types of issues? And John, I'll just ask quickly, have you figured out kind of audio issues? It seems like we had a number of people asking questions about that.
One person asked a question about it. I haven't seen the others.
Oh, okay, great. So as long as everybody can hear us. Okay. So now into the new framework, and again, this is kind of more nuts and bolts, kind of what's actually happening now. So in terms of kind of where we stand now, there are 4 pillars to this. The last pillar, the AI action plan, is kind of a policy document. It's not really binding in any way, but I still think it's worthwhile to talk through kind of what that plan says to see what's to come. That's the most recent action. That's from June of this year, right? You then have kind of an executive order that came out, and they're removing barriers to American leadership in artificial intelligence. That's the major transition from kind of the safety, let's be responsible about things, Biden executive order, to we need to be cutting edge, Trump executive order, right? So that's kind of the big thing there. And then out of that came the 2 controlling documents for government contractors, essentially. So OMB M25-1 and -22. Hopefully we won't have to use the numbers that much, but the -21 authority is about federal use of AI. So that's what I talked about earlier on that executive order, that it's the government's own internal use, but could still be relevant to contractors, but it's the government's own internal use. And then 22 is really about government contracts, right? So the government procurement of AI, it's actually less detailed. It doesn't have as many kind of binding issues to consider as the -21 government use of AI memorandum, but it's still, obviously relevant. And so we'll cover that a little bit. And again, the action plan is kind of more of a policy-based document. I will say, it's not going to matter for 99% of the cases, but there's even a split among these different authorities issued by the administration as to which definition of AI to use. And so it will be interesting when the FAR ultimately gets interested how they how they settle on a definition of AI, because that will be relevant, where there will definitely be some automatic applications of software that people kind of question, look, is this a pre-programmed thing, or is this some kind of AI that's covered by the definition? Where does it fall on the spectrum? Okay, so government use of AI, essentially what they did, and there are some exceptions to this that we can walk through, but what they did was they looked at the rights impacting and safety impacting framework of the OMB memorandum under the Biden administration, and basically just rewrote it to say, okay, it's all now called high impact, and that's what we're dealing with here. So what happens now is there's a risk management framework where agencies have to sit down, among a couple of other steps, but their major step under this is they have to sit down and think about, whenever artificial intelligence is involved in what they're doing, is it a high impact system under this guidance? And if so, they've got to do all sorts of steps. And again, that's going to be flowed down to contractors, right? So that's kind of why this is all relevant to government contractors generally. So what it looks at is it has a very, very broad definition of, well, high impact is just, the output is the principal basis for decisions or actions with a legal, material, binding, or significant effect on rights or safety. That's pretty nebulous, right? They give a little bit more of a kind of detailed definition in the framework in the memorandum. And they refer to things like, look, it's impacting individual rights and liberties. It's impacting insurance credit, medical issues, health and safety, critical infrastructure, public safety. I think the biggest maybe catch-all for that might get a lot of contractor unawares is that it refers to strategic assets or resources, including high-value information marked as sensitive by the federal government. So if you're familiar with controlled unclassified information and things like that, basically everything is controlled unclassified information now, in my opinion. And there, you might start to see a lot of agencies say, well, it's high impact because we think this data is important, right? Even if it's not keeping somebody alive, even if it's not keeping the lights on, right? Some kind of very, very important thing. So I think this is probably going to be a little bit broader than it was originally intended based on some of those definitions. A couple of takeaways, essentially, if you have human oversight, so you might be familiar with the concepts, they'll call it human in the loop or human on the loop. Human in the loop is somebody says yes, right? They kind of say yes or no to the decision, firing nuclear missiles, whatever it is, right? Yes, no, somebody has to make that decision. Human on the loop just means, yeah, they're being informed of kind of decisions that are being made by the AI and they're able to stop it, right? But they don't have to kind of approve it in any way. And so having any kind of human oversight in the loop or on the loop doesn't matter, right? It's really just about what is the impact on the system. So you can't just say, well, it's always approved by the agency. It doesn't matter for this framework. There's also a list, and we have a slide on it, on kind of things that are presumed to be high impact. So you definitely, you have these super broad definitions of what high impact is, but at least there's a list of kind of governing, look, these ones are presumed to be high impact. You could make a case that they're not in particular instances, but if not, we basically have to go with that. And essentially the CAIO, so essentially they now have a new official for each agency that is the chief AI officer. That chief AI officer has to expressly say, when you fall into one of those presumed categories, no, we're not going to do that. Essentially it's not actually high impact, even though it's presumed to be high impact under the memorandum. Important thing for contractors, the determinations about what's high impact versus not high impact can be reversed at any time. So that's terrible from a planning perspective and all sorts of things. And we'll talk a little bit about that has some implications for equitable adjustments, getting paid, right, things like that. But basically, you can go into a contract thinking you're not high impact and they can change their mind afterward, right? And then there are all sorts of questions about what happens at that point in time. The other thing is that there are a couple of deadlines. So we'll mention an April deadline of next year, a deadline at the end of this month, and a deadline in November. So the deadline of April, the latest one, April of next year, is when all this goes into effect in terms of the government use. So a lot of the other stuff is kind of ramping up to that. But in April of next year, the government is supposed to start following this risk management framework, identifying high impact AI that it's using, or discontinue the use of the AI, right? That's kind of they have to do this or else they can't use it anymore. A couple of exemptions throughout here. So there are, I mentioned none of these requirements apply to national security systems or the intelligence community. That's kind of subject to a separate set of requirements at the end of the presentation in the appendix. Also, it doesn't apply to the AI information generally. So I mentioned that some of these definitions of AI are so broad, they could cover an entire robotic system, for example, or something like that. This guidance expressly says, no, look, we're talking about the AI component of the firmware or whatever it is that's going on for that robot, right? So that's kind of another kind of narrowing aspect of it. It also doesn't apply to pilot programs that are of limited scale or duration, as long as the chief AI officer certifies to that effect. So if you're doing some kind of interesting novel application of AI in a particular area, you might be able to essentially get a waiver, right? A short-term waiver that says, well, this is a pilot program, it's limited scale, that it's a prototype, right? That kind of thing. So that's something to keep in mind kind of going forward on the contracting side. And then also it does not apply to basic or applied research. That's a pretty broad category as well. The idea is that the research communities, the National Science Foundation and others were supposed to develop their own standards. They still have not done that, and I expect they're not going to be nearly as stringent as these standards. And so if you're doing research development contracting with the government, maybe even some forms of prototyping, depending kind of where it stands on the spectrum, you might be able to make the case, look, this OMB memorandum and risk management framework doesn't apply, so we don't need to worry about it. So what has to happen? I mentioned there's a major thing and then kind of 3 or 4 ancillary things. So when it's a high impact system, the agency has to take these steps. So the agency has to do pre-deployment testing. So they have to, before using the AI, do some kind of test to make sure it's doing what they expect it to do and it's consistent with their impact assessment, which is the next step, which we'll talk about in a second, of kind of expected impact on the public, individual rights, liberties, safety, all that kind of stuff. For a contractor, the key is that the testing framework refers to, oh, well, maybe you could review the source code, maybe you could review the algorithm model and weights, maybe the data sets that are used to train the model. All of that's very upsetting if you have an AI system and you're kind of worried about your proprietary data. What's helpful is there is a reference to alternatives there. So we'll see which way agencies go as they deploy this over the next 6 months. But essentially they say, well, look, you could do a system where you work with the contractor for the contractor to run the test in a controlled environment and then give you the results, right? And you're supposed to do it in an environment that's simulating kind of where it would be deployed anyways, right? So there is a pre-deployment testing requirement. We don't have implementation in the Federal Acquisition Regulation yet, but I would expect there's going to be some kind of, either you're going to get terms in your solicitations or you're going to get a FAR clause that talks about pre-deployment testing. The next is the impact assessment. And this is probably the biggest one to think about from a contractor in terms of marketing, preparing data for the government, things like that. So an agency has to make an AI impact assessment whenever you're dealing with these high AI, right? And essentially that's almost like a privacy impact statement if you ever dealt with a system of records under the Privacy Act or something like that as a contractor. But essentially that's kind of a, look, they have to do an evaluation and say, here's the name of the system, here's what it does, intended purpose and benefits, what data was used to design and develop it. So what was it trained on, right? Not necessarily the specific data in terms of all of the data available, but what categories of data, things like that. How could this impact the public, if at all? If you've ever read a Federal Register notice on anything, right? Those kinds of statements. How often are we going to be reevaluating this, right? And what are we going to reevaluate it against? So every 6 months, a year, to see how it's being used in the government. What are the costs and expected savings to the government? How are we doing an independent review? So independent means the non-purchasing component of the agency. So agencies are going to have to set up essentially AI review shops or have another component of the agency review things like that, just to say, yeah, I kind of agree with what's going on here. And then I think importantly, identification of the agency official responsible for this whole statement that's being put out there, right? And that's really important because if you ever dealt with authorizations to operate under FISMA or FedRAMP or these various kind of information technology or cloud service computing requirements in the government, it's going to be, I think, a similar framework where you're going to have somebody individually responsible in the government for signing off on these things. And if you've ever encountered any of those issues before, that's likely to be a total pain because somebody doesn't want their name attached to something if they feel like it's a new cutting edge novel application or something like that, right? So you'll probably have a lot of push and pull with respect to that last requirement of identifying the agency official accepting risks. What are the other requirements under the risk management framework? So you have ongoing review. So there has to be kind of where feasible, it says, this is one that's qualified, but essentially the agency ability to ongoing with a human say, is the AI still being used properly? That's the reassessment schedule and things like that I talked about. You have to have training for agency personnel and kind of evaluation of the AI that is specific to the particular AI. So we'll see how kind of granular they get on this, but it can't just be every government official gets AI training. It's training and identification of individuals using biometric data, using AI, right? Like that kind of level of training is likely what's to be required. And I wouldn't be surprised if agencies push this down to contractors as well as a contract requirement. You have to have human interventions and fail-safes. So essentially human on the loop instead of in. So the human has to be able to stop things, right? So that has to be a component of the AI and enough for them to actually know when to stop things like that. Fail-safes for it's clearly about to do something terrible, right? That kind of thing has to be considered and included. And then if the AI is impacting individuals and their rights in any way. So let's say the AI is being used to process asylum applications, something like that. There has to be a timely human review option and appeal. So if you're designing AI for the government, and you think it should be used in a new application and that's going to impact somebody's rights, just realize there's probably going to need to be an appeal process in that somewhere that would have to be baked into kind of that pitch to the government. And then finally, this is an odd one. It has to be capable of accepting end user and public feedback where appropriate. So kind of a contact us type line if the public is engaging with AI in any particular way. So when you're designing things, that's another thing that will be required going forward. So in terms of kind of, if you're not on the presumed high impact AI, how should agencies and kind of by proxy contractors consider whether something is a kind of particular high impact risk AI? So a couple things that they mentioned there, right, essentially is if it's an AI that's just giving information, it's extractive, it's summarizing reports, it's going through litigation case documents, things like that, probably not as much of an issue. Whereas if it's fully automated and making decisions, performing tasks, things like that, that's a heightened risk. Degree of human oversight, obviously, how much the human can be on or in the loop is important. Whether I think these two are interesting, kind of the obviousness to the user and then just the circumstances generally, whether an AI is involved, that's important, right? So if it's obvious to the user, great. If it's not, that might be a problem or at least heighten the risk. And then same for the circumstances involved. If they're doing a chatbot with the government, it's not clearly a chatbot and they think they're talking to somebody, right, is that that's going to heighten the risk if somebody is kind of, there's risk of confusion essentially. There's also kind of discriminatory output issues, facilitating harmful or unsafe actions. All of those are kind of obvious, I think. The cyber kind of posture of it. So how could it be misused, right? If somebody kind of prompted it in a particular way, tried to get at the data sets it was trained on, that kind of thing. And then also what types of data sets is it maintaining, right? So if it's maintaining data sets. So essentially, if you have a model that was already trained, you can't kind of prompt back into the data set, it's not an issue. But if you're continually updating, well, if it has a lot of social security numbers in terms of the application that you're thinking of, yeah, that's probably going to be a high impact AI type situation. And then finally, the presumed high impact kind of issue. So here essentially is the list somewhat summarized, right? I try not to just give a verbatim thing and combine where appropriate, but a list of what would be high impact unless a chief artificial intelligence officer says otherwise, right? And so safety critical functions for critical infrastructure, that makes sense, you know, electricity, water, things like that. Physical actions, so any kind of robotics, right? If it has potential for significant injuries, so you could think of industrial applications, right, where there might be something like that popping in. Hazardous and chemical biological agents, so that might be transportation, might be development, all those types of things. Medical care makes sense. I have an insulin pump. If it's using AI and fails, that would be a very bad situation, right? Oddly, also decisions about allocation of care and insurance issues. So kind of on the business or finance side of things is covered there as well. Trade restrictions, so you know whether somebody gets an export license, that kind of thing, or whether to impose sanctions, right, is kind of included there. Law and immigration, so a lot of applications for AI that might be sold to the government would have kind of issues here where it's helping process or identify people for immigration risks, right? Forecasting for criminal activity, recidivism, going back to prison, right? That kind of thing. Those are all high impact. Individual tracking or speech restrictions, so biometrics in public places would be presumed high impact. Adjustment of public benefits, that kind of stuff. Federal employment decisions, so hiring in the federal government, and then language translation, where you know the impact actually goes on somebody's rights and gets to a legally binding decision. So if you're doing language translation of just massive, you know, news communications for the government, and it's just being for informational purposes, maybe that doesn't fall into the category, but otherwise it would potentially. Now, the ones I always think this is interesting just to compare, I mentioned the rights impacting versus safety impacting framework that the Biden administration adopted and the Trump administration kind of just adopted much of the same thing. Well, the exceptions to that, just to list through a few that are on the prior list but are not on the new list. Voting infrastructure and election integrity, controlling industrial emissions and environmental impacts, detecting presence of dangerous weapons, detecting emotions, thought, impairment, and deception in humans, so lie detectors, that kind of thing. Replicating an individual's voice or likeness without express consent. So that could be a big one for a lot of AI applications that are out there now, so that's no longer kind of presumed. And then all sorts of kind of screening for mortgages, loans, rental, all that kind of stuff was in there previously. And then the last was the former list covered employment decisions generally, so hiring in a commercial business. It is only the federal government now that they don't talk about kind of employment decisions that might have an impact on some contractor or something like that. It's only kind of federal hiring for AI uses there that are presumed high impact. Now, what happens if essentially, the agency doesn't want to do any of this? Well, there is a waiver option. It has to go to the chief artificial intelligence officer. There's a whole process behind it. And it's requirement by requirement. So maybe you don't do training. Maybe you don't do the impact assessment. Maybe you don't do X, Y, Z, but it's not, the whole thing automatically. It's individual requirements. And there, essentially, they have to determine that, look, following this would actually increase risks, right? So maybe publishing something would increase risk to individuals. Or the broader catch-all that would probably be used in most situations, doing so creates an unacceptable impediment to critical agency operations. So there is a carve-out for it's just really important to Department of Homeland Security, right? And if you can get the right person to issue that waiver is there. It has to be continually certified and validated each year. It must be reported OMB, right? And then I think the important thing is it can also be revoked at any time. So just like the high impact kind of statement can change anytime during contract performance, a waiver can be revoked or not renewed the next year or whatever it is. So if you're relying that on in a contract, you definitely could have a risk there kind of going forward. And then I think the other helpful thing is if you're looking at competitors or your own situation, waivers are, where possible, supposed to be public, right? So you're supposed to be able to go to a database ultimately April of next year, start seeing these waivers, start seeing whether an agency has ever issued one, right? They might just never have issued one in that particular agency. All of that's supposed to be kind of public going forward. Okay, now for the last kind of piece of this before the contracting one. Essentially, the last one that I wanted to kind of reference here is the data and model sharing kind of issues. So intellectual property, data access, things like that. So the risk management framework really focuses on this high risk, or I should say high impact AI, and kind of what you have to do there with the impact statements and the reviews and all that kind of stuff. There is also a statement about AI generally in there, I should say a number of statements that are not specific to high impact AI. So anytime the federal government is using artificial intelligence, these issues should be considered. And it's very, very important for government contractors. So essentially, there's a lot of talk coming back from the original executive orders and now in the memorandum much more expressly about, look, agencies should be getting the equivalent of government purpose rights, right? The ability to use the AI that's being delivered to them and take it from Department of Homeland Security and give it to Department of Health and Human Services, right? That kind of thing. So there's a government purpose rights kind of push, and then access to kind of data that's being used to train and even improvements to that data. So labeling, things like that. And that's whenever the government is kind of doing what they call custom developed code. And so that's they're either producing the system for the first time in performance, or it's something that's kind of unique to the government. So an application programming interface, something like that, where you created something to interface with the government system. So if it's a purely commercial kind of system, they're not saying this, but if you're doing any kind of development work for the government in the AI space, they're talking about, look, government purpose rights is the default. Now, I'll tell you, there's an exception in there that says, oh, we shouldn't do this for private intellectual property. I think that's kind of being ignored in how this is being rolled out, and you'll probably see a lot more focus on government purpose rights, but there is this kind of talk about that there. I mentioned the kind of obtaining rights in data sets and labeling and things like that. They also have a big push on including contract terms for kind of avoiding vendor lock-in. And so that could be done through rights, saying, look, we just get the rights to whatever you've delivered. Or, if you're a contractor, you would push them much more in the direction of, no, that means you should be doing modular architectures, things like that. And that's something that's been around for a while in the Department of Defense. But the idea is you do a plug and play system. Yeah, we're going to give you an AI application that's great for using biometrics to identify individuals. And we'll provide you with the application programming interfaces to talk about how our AI system will talk to your database of individuals. But you can keep the API, you can keep the talking portion of the software, but we should be able to take ours away at any time, and you just go put in somebody else with their biometric identification data, right? That kind of framework where it's supposed to be the government's component, your component, you could take out your component and plug it back in, instead of we're going to do this monster of combining everything together, and that's part of our development project. So that's what they mean by kind of modular architectures. And then I think one trend that you've seen significantly started in this memo, and there's now a proposed rule for it. I think this could have a huge impact on contractors for using AI, is there's a big push in the memo and now in this proposed rule to prevent contractors from using government data for their own internal uses. So that might even be independent research and development for the government, whatever it is, but just if you have access to the government's flood database of insurer claims, you might think, great, we're going to train our AI as we perform in the contract. Not so fast, right? They're talking about essentially that would be prohibited going forward. So it's not right now, but that's definitely something that's being looked at, and there's a proposed rule for it right now. And then finally, there's some discussion about kind of data provenance and things like that. So essentially requiring contractors to disclose, where did you get your data? What is your data? Did you scrape the internet, right? That kind of thing. And so there probably will be some contract terms around that going forward. Okay, and then John, do we, I'll look at the questions here to see if there's anything particularly relevant. Did you want to do the next password now, or do we need to wait a little bit for that? Okay, so I think maybe John stepped away. So we'll go ahead for government procurement of AI.
Sorry about that. What was that, Tyler?
Oh, no, I was just saying I was going to look at the questions, and did you want to do the password now, or should we do that in a little bit?
Let's do that in a little while. You can take a look at the questions, though.
Okay, great. So I think, yeah, I think some of these we'll just kind of hold till the end, and happy to kind of do that. I'm just trying to see if there are any that were particularly helpful to answer right now. Yeah, I think a lot of these we can hold for a little bit, and I'll turn to them again in a second. Okay, so now, that was the risk management framework, high impact AI, and the government talking about what it wants for its data rights and access to data and provenance, description of data requirements, and all that kind of stuff. Now, I said it's less detailed, but the second piece of this that was actually kind of finally having a practical impact instead of just policy statements and executive orders is the OMB memo on government procurement of AI. And this somewhat puts the kind of government use memo into effect. So I mentioned government use memo April 3rd, 2026. That's the deadline for government-wide kind of compliance outside of intelligence community, outside of national security systems, to comply with that framework. September 30th is when the government procurement rules are going into effect. And the idea is that these are supposed to ramp up as solicitations get issued to get to that April 3rd deadline, right? So starting on September 30th, it would be for new solicitations, and then importantly, options and extensions, right? So not just, new solicitations only. If you have an existing contract, this could be worked in. Essentially, you're supposed to be implementing kind of the new government procurement rules if you're on the government side of things. And then as a contractor, you're going to start seeing these in solicitations and contract mods. There is a blanket exception. So it has the same exceptions as the other memo, right? So for pilot programs, research and development, national security systems, all of that is exempt as well. But there is also a broad exemption that's actually based on a statute that talks about AI that's used in common commercial products, or embedded in common commercial products, I should say. And they kind of describe that as, look, it's widely available for commercial use, and there's a substantial non-AI purpose or functionality. So the examples they give are AI used in a driving mapping software, right, is kind of one of them. AI used in word processing, Clippy with AI, right, something like that. So these very generic kind of examples. But depending on how that gets implemented, you could see a much broader kind of gap there where they say, look, it's this commercial product exception, that kind of thing. We'll have to see what happens. I don't think it's going to be a commercial products and services, commercial items as you understand them under the Federal Acquisition Regulation are just completely exempt. I don't think that's really the intent of how these memos have been drafted, but it probably is going to be something closer to, a COTS item or something like that, where you could maybe get exempt, and that would be commercially available off the shelf items if you're familiar with those concepts. The incidental use exception is also there. So essentially it does not apply if the AI is being used incidentally to performance. So if a contractor is using AI for internal employment decisions or as part of word processing or something like that, not going to be covered by these standards. It has to be directed or required to satisfy contract requirements. So it's really kind of a key part of the contract. And if you're familiar with Section 508 requirements on electronic information technology, essentially accessibility standards for PDFs and things like that, there's a similar standard there where you kind of say, look, if we're doing our own internal reports, we don't need to make things, accessible to the entire public in terms of disabilities and things like that. It's only for things that are published on a government website, right? Stuff like that. And so it would be a similar kind of analysis, I think, for a lot of the AI issues. And then I already mentioned it's subject to the same exceptions on, research development, all that kind of stuff. So then you get into kind of what are the specific requirements here that the government is going to be required to do starting September 30th, end of this month. So just a general policy matter. This one's not kind of you must put this in solicitations, but the government is being directed to look at performance-based acquisition techniques for artificial intelligence. So that means if you're familiar with broad agency announcements, commercial solutions openings, things like that, a lot of them use statements of objectives instead of statements of work. And that sounds like semantics, but the difference is the government just says, here's a 5-page document on what we're trying to accomplish. And then the contractor comes back in their proposal and says, here's how we're going to do it in our detailed statement of work. It's not the government saying, every week you shall do this and you shall submit these reports. It's not kind of at that level of detail. So they're being encouraged to kind of go to the broader statement of objectives position. Kind of detrimentally to contractors, that's positive to contractors, I would say in many instances. On the detriment side, that's also a focus on kind of quality assurance. So service levels, incentives for desired results, right? So incentive contracts, things like that are really being pushed kind of in the artificial intelligence realm. General Services Administration has kind of signed on to that. They're doing a lot of this right now. And so you'll probably see those types of contracts being issued, fixed price incentive, stuff like that, right? The helpful thing is the government is supposed to be identifying whether they think the AI system being provided is a high impact system. Obviously, that matters a lot because if it's not, you're not subject to the whole risk management framework. Also, the documentation that the agency is going to require to allow them to complete their impact assessment, right? To kind of go through that whole process and testing and things like that. They'll also they're supposed to, right? They're supposed to do these pre-deployment tests. That's supposed to be part of the evaluation process, not just kind of you won, now let's test to see if it works, right? So you'll probably see some of that in terms of evaluation criteria and things like that in solicitations. And then, you're supposed to, the agency is supposed to be able to say, like in their evaluation itself, so the evaluation document, we've considered the risk management framework if it's a high impact system, and here's what we think about it and what we're going to do to mitigate risks that are around this, right? So all of that is supposed to be there. And then what they're supposed to be doing mitigation wise is supposed to be worked into the contract terms at award. And so that's why kind of the whole risk management framework is very relevant to contractors, because it's going to be part of the evaluation process and part of the award process. It's supposed to be starting at the end of this month. I wouldn't be surprised if it kind of slips a little bit, but that's the overall kind of framework. In terms of contracting issues to consider, absolutely, I think there's going to be a lot of fights about equitable adjustments. So essentially, I mentioned they can change the designation of a high impact system at any time. Well, your contract doesn't say you have to now satisfy everything, right? So depending on how they implement some of those FAR clauses and getting all this out, you could have a situation where, look, they decided later it was a high impact system based on how it was performing. They say you now need to submit all these documents, open your software up to audit, do additional testing, allow the government to shut things off, right? All that kind of stuff. Okay, well, you now need to pay us because those are all additional requirements that you did not put in the original award. So just keep in mind the baseline contracting requirements still apply in the background to all this, right? You can still kind of get recoveries and things like that. And then the other thing would just be bid protest, right? So thinking about, have they really considered the risk management framework and their evaluation criteria, all that kind of stuff. I could see a lot of strategic bid protests to influence solicitation criteria or protest the actual evaluation results based on non-compliance with the OMB memo and some of the requirements on the risk management framework. And then finally, the kind of contract terms, how does this get played out after an award is made? Well, there's no hard requirement on this yet, but the memo talks about agencies should really be preferring AI that is developed and produced in the United States. What that means, we don't know. But there have definitely been instances in the past where there's kind of a US preference for software, particularly in the intelligence community. So you could start seeing that kind of thing about the nationality of the programmers involved, all that kind of stuff. Just remember, and this is kind of reiterated in the memo, all of the background stuff still applies to information systems and systems of records, databases, things like that. So if you have Privacy Act issues, you're dealing with personally identifiable information, all that still applies to your AI system, right? And so you're going to have terms applying in that way. Same with authorities to operate. So you're using kind of an AI system in a government information system, you now need an authority to operate based on FISMA and some of the other requirements that are out there. In terms of contract terms that are recommended, so you might start seeing these types of things, terms that would prohibit commercial use of non-public data. So again, training on government data is probably going to be a big issue and likely prohibited in the near future. And again, there's a proposed rule on this even separate from the memo right now. Transition requirements, so making sure that vendors have an obligation to help transition a new AI provider. If that's going to be the case, they almost treat it like services in many ways. Interoperability issues, like I said, make sure your application programming interfaces are subject to government purpose rights. You can give them to the other contractor, your replacement contractor, that kind of thing. Talk about licensing in general, that gets to the government purpose rights issues. And then they even get into, I'm a little bit fascinated by this, a lot of pricing considerations. So essentially saying you shouldn't let contractors do things like induce you into a subscription that only makes sense if you sign up each year for 5 years, right? Like that kind of pricing type, low loading at the beginning if you have kind of a long-term subscription. And so there is a big push against that type of pricing practice, maybe even most favored customer pricing like the GSA has, things like that, to address some of these vendor lock-in concerns. And then they do have kind of audit provisions and things like that. So you're probably going to see in the FAR implementation, the agency being able to go and make sure the AI is doing what it's supposed to be doing if you're running it on your own cloud server as a contractor, that kind of thing. All right, so I'll pause there. And John, we got about 15 minutes. Do you want to give the other code?
Sure, we can give the second code now. The second password today is the word day, D-A-Y, day, day, D-A-Y, day. Thank you all.
Great. Okay, so then finally the action plan. This is mostly policy based. So again, I'll just kind of hit on some of the main topics here because it's not kind of being implemented in a particular way right now. But there is a big focus on states implementing AI restrictions that are problematic for the federal government and maybe withholding funding from those states. So California, Colorado have kind of more robust AI regimes right now. Texas almost had one, right? And so there's likely to be a lot of back and forth based on state regulation versus federal regulation based on this action plan that came out in June. There's a big focus on content moderation. So are you suppressing voices in a particular way, right? On the flip side, they don't want any references to DEI, climate change, that kind of thing. And so there are even kind of discussions of making sure that AI systems do not prompt in that way, right? That kind of thing. There's an executive order out right now, and this is the third deadline that I was mentioning at November of this year, but it could extend to February based on when they issued the original guidance. But between November and February of next year, November of this year, February of next year, there's an executive order on content moderation for large language models, and essentially says, look, you can't, it's the preventing woke in, AI in federal government. You have to make sure that your models that are being used by federal employees are truthful and ideologically neutral. So truthful makes sense, right? Using objective data, acknowledge uncertainty, that kind of thing. Ideologically neutral could be pretty broad and interpreted a lot of different ways. They say no intentional encoding of judgments, right, unless prompted by the user. Fortunately, it does give kind of a safety valve there that says, look, when OMB is implementing this, the Office of Management and Budget, you should allow for some kind of compliance where the AI provider discloses their system prompt, right? So things behind the scenes that the user's not necessarily seeing, but that rephrase their question in a particular way to make sure that that's not kind of injecting ideological bias, right? And so as long as you're kind of disclosing that, that might be kind of the safe harbor to say you're not in violation of this requirement. They can start modifying contracts kind of once this goes into effect, even if they're existing. So if you've dealt with the ByteDance or FAXA or all the various things that have come over the last couple of years, you'll be familiar with that process, but they'll probably try to force modification on you, even though they technically can't insist on a modification in that way. And then they talk about making large scale compute available again, and then a kind of R&D plan for both, open source and open weight models. So there's still talk and emphasis on that in the overall plans. In terms of if you're in a regulated space, so you're doing financial services, doing kind of loans under a SBA loan contract or something like that, and you're using AI, right? There's this emphasis on agencies kind of allowing for regulatory sandboxes, and that's the thing that's been used by a couple of agencies, particularly in the finance field, where they basically say, look, we'll approve whatever project, and even if it's technically violating consumer protections, you have a non-enforcement agreement, like for this particular project, to see if it works out, right? So that's kind of one thing that they talked about. A couple of other highlights are, the widespread access to frontier large language models. So you probably saw that almost all the large AI providers now have agreements with the federal government to make their chatbots basically available through August and September of next year, essentially for $1 for most of them, I think 76 cents for another. A lot of the talk about, you've probably seen about onshoring of the actual kind of compute power, right? So that's a big piece of this, that if you're not on the software side and actually the semiconductors and things like that, that's still coming along. And then I think the big one that I was always shocked at is no reference to intellectual property whatsoever, right? So there's no discussion of infringement, respecting people's copyright, all that kind of stuff. And Trump even made a statement on the same day saying he didn't think AI could be developed in that way, essentially, if people were to insist on enforcing their copyright for training of models, right? That it just wasn't possible to have massive AI without that kind of infringement. So that's the action plan overall. In terms of the takeaways, what all this means for contractors, I would say the high impact thing is the big thing, right? So that consideration of what constitutes a high impact system when it's being used in services performed for an agency or provided to an agency is going to be big, because that will influence the solicitation requirements, the contractual requirements, and you're probably going to get something that's ultimately like the system of records requirements for the Privacy Act, or FISMA requirements or FedRAMP requirements for cloud services, things like that, where you have a particular FAR clause, DFARS clause, whatever it is, it says, here are all of your heightened requirements for your high impact AI system. And that's coming. There are already bases for kind of doing that. Whether you can escape that through the common commercial goods exception or the incidental AI analysis, you did that for ByteDance. I mentioned Section 508 requirements, things like that. That's probably going to be a big part of this kind of rolling out on the contractor side to say, look, are we supposed to comply with this clause or not? You'll see government audit rights. So there's a lot on kind of the government being able to see behind the veil, access contractor servers, things like that, to make sure that things are going according to plans. That will probably be part of these kind of clauses. And then you'll probably see a lot of stuff about either intellectual property rights or localization. So where data sets have to be established. If you're familiar with or maintained, I should say, if you're familiar with the cloud computing requirements, those had a localization requirement kind of saying, look, you have to make sure that the servers are based in the United States, right? So the same kind of thing would apply for a lot of these AI things, or might apply as they kind of implement these rules. And then finally, code access, data rights, all that kind of stuff. I've already seen plenty of contracts involving more cutting edge AI where you're seeing insistence on government purpose rights, insistence on access to data sets, all that kind of stuff is likely to come. For the cybersecurity standard, or for the standards that might come out, there are already a number of NIST standards that govern adversarial attacks against AI, how to develop AI from a risk management framework, all that kind of stuff. I've listed them here. They'll probably implement some of these in the FAR clauses that implement these OMB memorandum. I would also keep an eye out for, I think it's probably going to be based on all the language so far, use of AI and performance or delivery of AI to the government, not if you're a government contractor, all of your AI now has to do X, Y, Z. But just keep in mind, you had Section 809 requirements for Huawei, telecommunication devices, things like that. There are instances in the past where the government's basically just said, well, no, if you're a government contractor, this is how you do it, right? So we don't think they're going down that path, but it's not totally clear without the FAR implementation. And then, there's this need for data rights. A lot of this stuff about data sets and things like that might fall into these data categories they call operation, maintenance, installation, and training data, or form, fit, function data. And so you might see agencies aggressively kind of push their interpretations of whether certain data elements and data sets fall into these categories, because the government gets unlimited rights to those categories. So those are things to watch kind of going forward. Okay, and then, I said we'll talk about just kind of a couple of high-level IP things that have come up and are relevant for a lot of government contracts, and leave a lot of the kind of national security, kind of foreign access things for you to review in the future if you have any questions. And then we'll kind of turn to questions after that. I think what we'll probably do, John, is finish up with the IP and data rights piece here. And then if people want to hold on for some of the Q&A, they can do that. But otherwise, we'll kind of complete the full content before our time is allotted. So on the current kind of IP framework, a lot of people come and say, well, how is AI handled in kind of the commercial world for intellectual property, and how is it handled in government contracts? And the basic answer for kind of the hard IP patents, copyrights, is that right now, this can change, there's a lot of back and forth, but right now the guidance kind of is, if you use AI to help develop an invention, it's no different than using a statistical model on a computer. You're using a tool, right? And as long as you were kind of part of the thinking process and the AI didn't just kind of do it all by itself without any kind of meaningful prompting from you, you can probably still be the inventor, still get invention rights, things like that. Copyright, however, is kind of the opposite. And it's a little bit scary that I don't think a lot of people fully appreciate this. The current guidance on copyright is that anything the AI produces, even if it was prompted, so you say generate a picture of Picasso's Mona Lisa, whatever it is not copyrighted, the output. It's only things that the user then changes to that output. So you colored it red instead of blue, that kind of thing. And so that's very scary, because a ton of companies are using AI right now for coding, software coding. And the guidance would be, you don't have any rights in that new software code you've created. So that's kind of a big issue to watch kind of in government contracts and here, if you're thinking about how to protect your rights as you use AI with the government in various projects. Fair use, I apologize, spelled fair there, but fair use is something that, is definitely there if you're thinking more about the infringement side. We were using data sets and scraping the internet or scraping something else. That's still a debate that's going on in the courts. There was recently a positive decision finding that there was fair use in a particular situation. That's likely to be an ongoing issue. And then for contractors in particular, you have the authorization and consent issues. So a lot of you might be familiar that if you infringe something in a government contract, so you infringe a patent while performing a government contract, often the government gets sued. You're exempt from liability. You could be required to indemnify them, things like that, but you can't be sued directly, right? And that's if you have authorization and consent. That could be just based on the circumstances. It could also be based on a FAR clause that's included in your contract. Two big takeaways for that. One, the FAR clause standard in that would go into most contracts does not cover copyright. So it doesn't cover software in most AI applications. It only covers patents. So you're not safe in a lot of those situations. And then two, even if the circumstances said, yeah, the government kind of knew what you're doing, so we're going to say you're protected, that kind of thing. There's a whole black box problem of AI where even the developers and users don't necessarily know kind of exactly what's going on internally. And you'll probably see a lot of litigation around that where somebody says, the government couldn't have known. You don't even know how your AI operates in that way, right? So I think the infringement exceptions that government contractors typically enjoy are probably going to be very hard to apply to most AI applications. And then finally, kind of two slides on data rights. One, just issues to consider as you kind of think about this. I like to think about kind of three buckets or areas. So data sets with AI, the actual models themselves and algorithms that run in the program, and then the output, what they're spitting out, right? So I mentioned, 10 times already, there's a proposed rule saying you can't use government data for your own internal purposes. That's huge. If you're trying to train on something the government did, they gave you law enforcement statistics, you think this is great, I'm going to develop my product on this, that's going to likely be prohibited going forward. And we'll see exactly how they do that, whether there are exceptions, but that's a big thing right now. Government rights on updates and continual training. So a lot of AI is not static. You're updating it as it's being used. Just remember all the default data rights in the FAR and DFARS and whatever agency supplement. The agency is probably getting rights in many circumstances to those new improvements. And often you have an obligation to track those. So how are you going to do that if it's being, your algorithms being updated as you kind of go through performance? Those types of issues have not been worked out, but it's going to be a mess in terms of representations, false claims, things like that, where there's a big fight about what should have been disclosed versus not. The AI models themselves, I already mentioned that I've already seen a big push about localization, where they can operate in the United States versus outside the United States. Whenever you deliver third-party models, you're using some large service provider to help use AI in performance. Well, remember, the government gets rights in new stuff. And so if you're feeding things back to the service provider that's then updating their algorithm and improving their AI, the government has a credible claim that they have rights in that, and you should have gone and obtained those rights. Now, whether that's ever going to be litigated, that's another issue, but that's something there. I mentioned the copyright issue already, and then continued data restrictions. So a lot of contracts say, whatever is development performance, you can't use in other areas, or you have to go get the government's permission, that kind of stuff. And a lot of that would still apply for AI. So just keep that in mind. And then finally, just a list of risks here, but there are all sorts of things that come up with data ordering clauses. If you use AI in performance of a government contract, in a civilian contract, they can ask and order your data set, essentially, everything that was used, even though you never intended to deliver that. That's still out there. There are all sorts of rights under the Defense Production Act that the government can use to obtain this information. And a lot of this is summarized in this article I have there at the end. A non-paywall version of that is available on Steptoe's website if you just go to my biography, and it's a pretty detailed list of kind of IP data rights issues to consider as you go through on government contracting and AI. So again, the remainder of the pieces will be just kind of background for you on kind of if you're doing cross-border transactions, national security, things like that. That's the rest of the slides. And for everybody else, I really appreciate your time. I'll hold on for a couple minutes here and answer a couple of questions, but I don't want to hold anybody past their 75 minutes. So if you need to drop off, I totally appreciate it. And John, do you have any final words for people who need to drop off?
Yeah, I want to post the training poll. Please fill out the training poll for us. Tell us how we did today. We hope we did well, but if we didn't, we would like to know. I want to thank everyone for joining us, and while many of you will be staying for the Q&A period, I want to thank you if you don't. Thank you. Bye-bye.
Right. Thanks, John. So just to walk through a couple of these, and again, we won't hold everybody too long, but some interesting questions I think that have come out here. So essentially, how is the government going to be using AI in evaluating proposals? I think that's a great question. There's no guide on that to my knowledge right now. But from a bid protest perspective, oh my gosh, the agency report that comes out that they couldn't explain why the AI said, this is better than that kind of thing, right? Obviously, it's more complicated than that. But I think that's really, I doubt there will be kind of restrictions on that because it's just like using word processing kind of thing. But I bet there will be all sorts of disputes about whether the AI was accurate. I would almost think about experts using AI in litigation right now, all sorts of disputes about how to track that, make sure it's actually viable for litigation and you can use it in evidence. Same kind of thing would come up in protest. So I think that's a great question. Another one is, the OMB memo 25-22, so the procurement one, that's really, really focused on government contractors. Will we see that in future solicitations, or is there a FAR? There is no FAR implementation right now. I've seen agencies start to implement it kind of unilaterally. I would expect a FAR implementation, and I believe one is being worked on right now, but that might come a little bit past, their deadlines at the end of the month, right? They don't even have a proposed rule. So unless they're going to issue an interim rule with all sorts of headaches, I doubt that's going to happen. And we'll just see if there may be one or two others. Yeah, there's just a question about, what about individual litigation against the government when they're using AI and things like that? So just aside, from government uses, like how does that work, right? If the government is kind of using AI in terms of how they determine your benefits and things like that. And I would say, yeah, there's that part of the first memo that talks about, well, you have to have some kind of appeal right. And so that's definitely there. That's usually an administrative process. So it's like Social Security benefits or something like that. You could have a situation where the AI has actually harmed somebody. And that's a government contracts issue where, let's say it's product liability, right? It causes something to blow up, something like that, or it causes a ship to ram into another ship. There are actually stories of that already for AI systems. Essentially, you would go back to the traditional, well, the private claimant might be able to sue the contractor, might be able to sue the government. For the government, you have to ask whether it falls under the Federal Tort Claims Act. If it's the contractor, does the contractor have a government contractor defense under Boyle and some other precedent that's out there? Does the contractor have derivative sovereign immunity, derivative immunity under the Federal Tort Claims Act, that kind of thing? But there's a whole framework around kind of injuries that would just apply to AI, just like any other system, I think. And then I think, let's see. I think that's about it. John, did you see any others that you wanted to answer?
I think if we're good, we're good.
Okay, great. Well, I really appreciate everybody's time. And again, thank you very much for the questions.
Oh, we have a raised hand. If that raised hand wants to ask their question, I will unmute them. Nope, the hand did not stay raised.
Okay. Well, thank you all. We appreciate it.
Bye-bye.